Good afternoon, and thank you for joining us today. I would like to welcome you to Fortney Scott's complimentary briefing titled FAR Council Implements EO 14398. Federal Contractor Compliance Obligations Begin. This webinar will be recorded. Today's presenters are Fortney Scott attorneys David Fortney, Elizabeth Bradley, Sarah Mugman, and Nita Beecher. I will now hand the program over to Nita to start the webinar.
Thank you, Sarah. And I'm very excited to be joined by David, Liz, and Sarah to do this webinar. So let's go to the next page. I think you all know that we are Fortney Scott. And being a Washington, D.C. law firm, we have been very busy in these subjects that we're going to talk about in a few minutes, DE&I and what exactly federal contractors can do. Let's go to the agenda because we have a whole lot to cover and I want to start getting going. All right, so we're going to talk about the background, which is Executive Order 14398. We're going to talk about the new FAR clause, what it says, how it basically mirrors the executive order, implementation and enforcement, some interesting parts to that. Takeaways, there are some current sort of intermediate and then longer range takeaways you need to think about. And we are going to, if we have a few minutes, we have some open questions we're going to try and get to if we have time. So with that, let's go to the next slide. So first and foremost, how did we get here? Sarah, would you kick us off with the next slide to talk about how we got here?
Of course. So we're going to start off with looking at Executive Order 14398. So just over a month ago, this order was issued. It grounded its legal authority in the Procurement Act, which is what authorizes presidential directives that are going to promote economy and efficiency in federal procurement. So really the purpose of this order was to establish the administration's policy of prohibiting what it defined as racially discriminatory DEI activities in federal contracting. And because executive orders are, not self-executing, the order instructed federal agencies to then implement contracting, reporting, and enforcement mechanisms to carry out this order. So where this really becomes real for contractors is going to be after the FAR Council takes action, which is exactly what the order directed. As many of you are likely aware, that FAR Council is really what sets government-wide procurement policies and regulations. So specifically what the order directed was for the FAR Council to amend the federal acquisition regulations to include a mandatory contract clause that requires federal contractors and subcontractors to certify that they're not engaging in these prohibited DEI activities. But the order also doesn't want contracting agencies to have to wait for to use this clause before those regulations are amended. So it also directed the FAR Council to issue deviation and interim guidance for federal agencies to adopt. And that's really the reason that we're here today, because the FAR Council released this guidance just last week, and federal contractors really can kind of begin to see this contract starting as of now.
Liz, I think the next one is especially interesting. So I know everybody is wondering, what does this mean? What does this new executive order mean? And does it mean relative to 14173 that we've been dealing with for the past year? So we could go to the next slide.
Sure. Many of you are wondering, don't we already have a DE&I executive order? What is this? How is it different? And they are fundamentally different in the fact that, and Sarah talked on this, the foundations are different. 14173, it was founded in violations of EEO law, Title VII, et cetera, looking at DE&I programs from the EEO landscape and what was going to be a violation of Title VII and other existing laws. The new executive order is founded in a violation of contract law, and the definition of racially discriminatory DEI activities is found in the EO itself. and it's no longer looking for external legal support, meaning Title VII, et cetera. So that's one of the foundational differences. And then looking at some of the nuanced differences is I'll call it EO1. It was focused on federal contracts and grants. 14398 is federal contracts and contract-like instruments. So it does not cover grants. And that's what we believe as of right now. There's no to be covering grants. The other thing that's very important is the first executive order referred to illegal DE&I, and that was any of the protected categories under federal anti-discrimination laws. This new executive order is limited to racial and ethnicity-based programs. Big difference there. Another portion that we're going to talk about here in a moment is this new executive order has quotes around it about what the contract clause needs to be. The subparts are exactly, it needs to be a cut and paste into the FAR. The prior executive order simply had language along the lines of DEI programs that did not violate federal anti-discrimination laws, but it was not as prescriptive as this new executive order. And so that's sort of the foundational differences. And while it's both broader and narrower, meaning narrower in the fact that it's only race and ethnicity, but it's broader in the manner in which it's defining these programs, which we're going to explore, starting on the next slide.
Yeah, I think that's right. I mean, just, I think many of us had wondered as we sort of rounded the 12-month mark thereabouts into the Trump administration, whether DEI was sort of this initial kind of, shock and awe, and is it going to move on to another topic? Clearly, this new executive order, the stepped up efforts, which we're going to unpack a little bit today, indicates, I think, to us certainly that there's a doubling down. There is both a reaffirmation of the general principles and now these further refinements in how DEI is going to be implemented specifically in the contractor space. We still have the prior executive order, but for many contractors, their day-to-day compliance is almost going to be superseded by this new set of requirements that we're going to talk about. But I think, that certainly key takeaway is that the focus on DEI, broad-based. We've talked before about the multiple agencies. It's what I like to call a team sport within the administration. It's multiple agencies. Common facts can give rise to many potential legal liabilities, and that continues to be the case. But now the contractor liabilities really start coming sharply into focus on a very accelerated basis, these new obligations and implementation strategies. So that's, I think it is interesting, and I think certainly for contractors generally, this is another wake-up moment, and you need to really be on the ball here.
Well, with that, now that we've kicked that off, let's talk about this FAR clause and exactly what it says. And I'm going to kick this off with the definition. So, as Liz said, this really is a cut and paste from the executive order for those of you who have already looked at it. First and foremost, it gives a definition. That was one of the problems with 14173 and a number of litigation that is ongoing right now, is that there was no definition. Now we have a definition of what they consider to be racially discriminatory DE&I. And they've expanded it beyond Title VII, as Liz said as well, to contracting. And also, I think very importantly, whatever allocation or deployment of an entity's resources means, i.e., is this spending money out of your charitable as a federal contractor to support, let's say, Hispanic engineers or Black engineer groups? Interesting question. Already there has been a lawsuit filed over this language claiming it violates the First Amendment for that reason. Then we have the whole program participation and that last language of that are sponsored or established by contractor and subcontractor. Exactly what that means is more than a little unclear at this point. And I think that we believe in this place, I mean, they're talking about opportunities federal contractors provide to groups to use email, to use rooms, to go to conferences and that type of thing. David, Liz,
Yeah,
Sarah?
I want to just chip in, Nita, you call out the litigation on the challenge. So there's, so far to our knowledge, one judicial challenge that Nita called out, and it really hones in on the language up there: allocation or deployment of an entity's resources. It's a 3-count complaint. It's a very long complaint, 220 paragraphs, 40 some pages, filed in the District of Maryland. So that's the Fourth Circuit. And the first 2 counts really are premised on the First Amendment. And the gist of it is that by limiting how you can allocate or deploy your resources, that effectively potentially chills or dictates what your speech is. So that has a First Amendment. That is, you can't penalize, reward, or penalize people based on what they say or don't say. A very basic First Amendment challenge. The third prong, it's a 3-count complaint. The third prong is whether the Procurement Act actually authorizes the president to engage in these types of programs. That's a challenge that's been around for a while. Similar challenges were raised under 11246, and those are all typically settled out. But once again, we now have the same challenges being asserted under President Trump's efforts to pursue these new federal contractor requirements. Interestingly, the plaintiffs in that case did not seek a temporary restraining order. They have only sought a preliminary injunction. What that means is there's going to be a series of briefings, potentially an evidentiary hearing. We're not going to get an answer from the court, even the district court, for a matter of multiple weeks, maybe a couple months. So meanwhile, everything we're talking about today, barring some other unknown litigation challenge, is going to go forward as scheduled.
Yeah.
One other thing I wanted to mention, I'm sorry, Liz, just a second, is the disparate treatment aspect of this language, which we've talked about before. And I think that's going to be simple, like the Coca-Cola case that the EEOC has filed. Are whites or are blacks or some group being treated less well, giving disparate treatment compared to others? I'm sorry, go ahead, Liz.
No, and I think the thing to look at here is, even though there's legal challenges going through, how do you comply today? You're going to have to get into a position to be able to, you're signing these certifications. So, looking at this language, and this is where it's broader than Title VII. I'm going to use ERGs, for example, or your recruiting programs. This, you might have looked at, we're sponsoring these conferences, but there's no employment benefit to anybody who attends or participates. So you're thinking under Title VII concepts, these programs were not a problem under the first executive order, right? Now we're looking at this new language, and it's allocation or deployment of entities' resources and sponsorship of programming. Is that getting to you even attending and sponsoring a race or ethnicity based recruiting event, et cetera? One of the questions we still don't know, but this is where you need to start framing in to look at this differently than you did under the first executive under Title VII.
And the litigation isn't going to provide any sort of short-term relief. We have to deal with compliance now.
And with that, Sarah, you want to kick us off and talk about the actual provisions that came out of the executive order with the next slide?
Yes. So what are contractors going to be certifying to? So really what I'm going to lay out here first are going to be the obligations for contractors, and then, shortly touch on the couple of enforcement provisions as well. So initially, really the first obligation worth mentioning here is going to be that that contractors are going to be agreeing that they do not engage in those racially discriminatory DEI activities we just discussed during contract performance. And so, as we kind of touched on, because this term isn't really clearly defined across every application, or that definition might evolve, federal contractors really kind of need to make sure they're assessing that risk, before they sign. The next obligation is going to be providing information and reports that includes access to books, records, and accounts as required or requested by a contracting officer. And this matters because it's really empowering these contracting officers to audit and investigate federal contractors' compliance based on those documents, those books, records, and accounts. We also have the requirement here that contractors must report known or reasonably knowable subcontractor conduct that is non-compliant with this clause. And this really pushes that compliance obligation down the supply chain while also requiring prime contractors to monitor and assess their subcontractors' compliance. I just want to also quickly note that this knowable standard is going to be, pretty fact specific. So that's kind of another area of ambiguity there.
Yeah, I think this is the point. Each one of these we could do an hour on, I think.
Right.
But I think that what is reasonably knowable of your subcontractors, and there's a lot of strategies to be considering here. What level of monitoring are you need to have? And I think what's really important, this is not just on the prime. Remember, this subcontract provision, it goes in the prime and then every tier below. So each subcontractor has this obligation for their third tier, fourth tier, and it flows down. So getting your arms around what could be steps you could take to be comfortable with this subpart 4 is going to be important to be thinking about.
Yeah, no, and I think that that's not the only subcontractor related obligation we have here. The last one we're going to touch on is going to be the requirement to inform the contracting officer of any subcontractor lawsuit that puts the validity of the clause at issue or challenges it. And that's a little bit unusual for the fact that it doesn't really go toward compliance. It's more.
Well, I think where this is going to come into play as this clause is being put into existing contracts, if you have a subcontractor that pushes back on being bound by it and signing it, and it results in a lawsuit between you and your sub, that's going to be a notice that you're going to have to give to the government. So it is deterring companies from pushing back on the implementation, is the way I read that section.
And also don't forget the 8A various set-aside subcontracts that are there. Those that are based on race potentially need to be re-examined. It's a topic we'll talk about more, but this also puts this into sharp focus about if litigation results in that from one of your subcontractors, maybe now former subcontractor who brings a litigation claim challenging the termination of the contract, that you are to, this is what I call the rat out provision. You have to rat out the subcontractor.
4 and 5 are the rat outs.
Yeah, 4 and 5 are the rat outs. You have to affirmatively disclose information to your federal contract customer about what's going on. So, all right.
All right, let's move on to the next slide where we address, these kind of the enforcement provisions of this clause. So the government really has a range of remedies for noncompliance, and that could be contracts being canceled, terminated, or suspended. And this also extends to potential ineligibility for future contracts. So this is raising the stakes by going really at the heart of, federal contractors' ability to do business with the government. But there's also this clause here that compliance with the clause is material under the False Claims Act. And that's because materiality is a requirement to establish one of those claims. And by expressly stating that compliance is material, it's kind of increasing federal contractors' potential exposure to these types of claims, really regardless of whether they're pursued by the government or by private whistleblower actions.
This really basically embeds the concept that when you invoice the government, you are impliedly certifying compliance. So you have your contract certification, new, that's been added, and the billing and the government saying it's material term to our decision to pay the invoice that you have now certified you're in compliance. So this is a big deal. And I just want to point out the irony that we now are dealing with blacklisting, which is what we've seen before and wildly objected to. It's back. And it's, as Sarah just explained, so barring from future contracts.
And to that point, every invoice is a new certification of materiality.
Right.
Your assessment of your programs is not a point in time activity. It needs to be ongoing, and you need to be monitoring for things popping up in your workplace if you have managers implementing their own policies and procedures. So it's an ongoing actions that need to be taken.
Great.
So, Liz, who are the contractors that are going to be covered by this new clause on the next slide?
Very broad. So it is prime contractors, all contracts over 15,000. Have we seen a federal contract that's less than 15,000? Right? Can you do anything? Right? So it's all prime and subs at any tier going down if you hit that $15,000 threshold. Now, note, this is broader than, for example, 11246, the affirmative action provisions of 11246 didn't kick in till 50,000. You had some non-discrimination requirements at 10, but so it is a low threshold intended to be very broad. Commercial products and services, the only restriction here, it is place of delivery or performance is within the US. So if this is a contract for delivery of services or products outside of the US, that would not be covered. And then the one piece is contracting officers do have a discretion about whether or not they're going to put this provision into a contract that expires on or before December 31st of 2026. So this is intended to be a very broad provision. Nita.
Well, there's a couple of things. One thing that we keep getting asked is what about banks and depositories? They were specifically covered on 11246 under the regulations by OFCCP, which I don't know that we know yet whether they're going to be covered. Do we?
We do not. I mean, the reasoning for coverage under the former 11246 was that the FDIC insurance contract was deemed to be a covered government contract. That's what insures your bank accounts. Whether the same reasoning is going to be applied here, we don't know. We simply don't know. I assume the answer is yes, but I don't.
I mean, they want to take a broad application of it. Will this administration, as an initial blush, say yes, it's covered, and then you potentially would have to maybe litigate out that it's not? But I think if you have any sort of, I think the only thing that we know right now is not covered would be grants. I think that is the only comfortable place that we're saying right now.
All these other quasi contracts.
Yeah.
To Liz's point, I think we can anticipate the administration is going to read this very broadly, and anything they can shoehorn in as a contract-like instrument, a lease, a number of other things will clearly be covered.
Well, this should solve, though, that has to be in the US. Remember when 14173 came out, people, countries, cities, foreign governments were getting demands that they comply with 14173. So
yes, I think from the State Department. And I would also say, obviously, we have many clients that are involved supporting the current war efforts. And there's a lot of contracts for deliverables outside the US for many supplies and services. So those would presumably be outside the scope. All right.
Yeah.
So Liz, the flow down clause.
Yes. Okay. So I know we've hit on this a few times on the next slide. We've hit on this a few times, but this is the mandatory. There's a new FAR provision 52222-90. Has to be in the prime and every subcontract. So any tier. This is going to be a challenge for many contractors, I think. Identifying one, do you know, if you're not the prime, do you know whether your contracts are necessarily federal contractors? I know, especially in the days of 11246, many companies just assumed they're a federal contractor and they complied with 11246 because they weren't really in the practice of identifying every single contract that could trigger those obligations. You're going to need to know them now. Not only that, you're going to need to know who are your subcontractors on each one of those so that you can get this subcontract provision in. I do think that the if applicable language we used to put in some flow downs where put this in if applicable, I have a feeling your subcontractors are not going to be willing to sign this flow down, a contract with this flow down with a, if applicable in it, based on the False Claims Act hooked and some of those real liability issues, I think is going to cause alarm with that. So you're going to have to inventory your contracts and get your arms around it.
Just make one point that I think is implicit in what Liz just said. The obligations under this new executive order are not self-executing. They only come into play once they've been incorporated into your contracts. Now, to the point that we've talked about the amendment process that's going to be going forward. We've talked about the flow down. So if you're a prime contractor, you can anticipate your existing contracts are going to be amended. Those will be bilateral amendments. You're going to know that. The government's going to contact you, or there'll be a new provision in a purchase order that comes to you, and you'll be expected to agree to it. That is, once you're covered by that, that's what triggers the flow down.
Mhm.
Now, many large contractors that have an inventory of hundreds, if not more, of contracts, that's when that gets a little tricky. Like, am I flowing down for this subset? What am I doing? I think the best practical pointer that most are doing is, look, once as an organization we get covered, we're just going to turn on the flow down across the board. Yes, there may be pushback, but, and I'm not saying that that is 100% totally, what the law allows or requires, because the law requires it's contract by contract.
Mhm.
But as a practical matter, for those of you that are large contractors with many subs and trying to inventory who's under what contract, that's very burdensome, particularly within the short timelines here.
Mhm.
So I think many are simply, whoops, once we're covered, we'll click, we're now supplementing and implementing this as a flow down.
Well, with that, let's talk about implementation and enforcement as far as we know at this point. So, Sarah, let's talk about the timeline, which I love this timeline. I think it's so cool.
Well, I think the timeline's a little quick, but I don't love it. But
Well, I
this
mean,
is
I love the
a
picture of
summary,
it. Let's
I
put
will
it that
say
way.
that.
The timeline is just as compressed as it looks on your screen. So really, as of last Friday, per the Bar Council's direction, all federal agencies really should be including this language in all new solicitations and contracts. So really what that means is at any point you could see this clause come through. As of today, of course, the agencies are each supposed to kind of issue this language to its contracting officers so they can begin, incorporating that. And the next date I think that's really huge here is going to be July 24th, because this is really a dual deadline. By this date, all federal agencies are supposed to modify their existing contracts to include this new contract clause. And I think we've talked about the, kind of bilateral modification. And if a contractor declines to accept, then contracting officers have been directed to determine whether they need to continue with that contractor, cancel it for convenience based off of no longer needing it. So there's that piece. But also on July 24th, each agency is supposed to have reported to the White House really their efforts and where they stand with implementing this clause. So this next few months are going to be fairly busy with getting these into all contracts.
I mean, this is another report, another list that may be going to the White House.
It will be going.
That will be going to the White House. So if you are pushing back on your contracting officer and have not agreed to the clause in your contract, you will be on a list in front of the White House. And so this is, this dual deadline, it puts pressure both on the agencies to act and act fast so that they can say they've 100% implemented or they have a good report to the White House. But it also puts pressure on the contractor community to not be on the list of companies who have declined to allow it on their report.
And this will be reported to the Assistant to the President for Domestic Policy, Stephen Miller.
Yes.
Right. So I just want to emphasize, because I am quite confident that you need to think about, they have effectively an Excel sheet, a grid box on listing all the contractors, all the ones that they have now sought bilateral modifications of all existing contracts, what the responses were, green check, yes, yes, yes. Those that are red checks, they're going on the report. Is there any justification? And then the implementation of new contracts and solicitations. Has anyone pushed back on those new terms?
And then any of these the companies on this most recent list, also on the egregious D&I practitioner list that was sent to Stephen Miller, the White House, in response to the prior executive
14173,
right,
which we understand were hundreds of companies, because that was once again compiled nationwide from the entire contractor community. So we're effectively now replaying that, which contractors were initially perceived as being out there on illegal DEI, over aggressive, maintaining illegal DEI programs. That's list number one. List number two, those that haven't, if you will, complied with the new FAR requirements on these, and you can rest assured there will absolutely be follow-up by this administration to address that.
Well, in fact, let's talk about that. In the executive order, not in this particular FAR letter that was sent out, there is a provision that the director of OMB, the acting attorney general, assistant to the president's domestic policy, and the chair of EEOC will get together and identify economic sectors of particular risk. And as you said, we also have the list from 14173. And with that happy note, Liz, what else can happen?
What else? Yes. So moving the penalties for noncompliance. So potential debarment, obviously, is the most egregious. And that is if your failure to comply with FAR 25222-90. This includes the EO's definition of racially discriminatory DE&I programs, not necessarily Title VII. Again, debarment is the worst that can go. We all know that under procurement law. There's also suspension. Even when you have a pending investigation, they can suspend. So prior to an actual finding of a violation, you could be suspended from government contracting. Contract termination, the existing contract can be terminated. And this goes back, and I think Sarah mentioned it before, that if you're not willing to agree to this provision, they're looking at, is this contract still required to let the government terminate it for convenience? And they're going to look at any way to terminate that contract and remove you from government contracting. And then, of course, the False Claims Act liability that we've touched on a number of times. This is where DOJ gets in, potentially up to criminal sanctions on this for failure to comply with this executive order. So, and the FAR provision essentially. So the penalties are extreme, and I would not be surprised that they want to show that this provision has teeth. So there will likely be some, I think some aggressive use of these penalties to try to ensure compliance and sort of the threat of this show it has teeth.
Just say that these contract remedies, we've just described them generically, but the underlying dollars can be very, very significant, far in excess of what we normally think about for EEO compliance, even taking into account broad systemic classes. Loss of the contract termination, the contractor can be responsible for all damages the government incurs in having a new contractor be substituted, any increased costs, et cetera, not to mention the cost of loss of that contract, future contracts. False Claims Act contains civil penalties, significant penalties. And these are, we're talking often tens, 20s of millions of dollars, sometimes more than that, hundreds of millions of dollars. So these are very, very significant financial exposure to the organization. This is not, and I don't mean to minimize, an EEO violation,
no,
but the proportional exposure here is multiples more than a typical, even a class-wide or pattern and practice EEO violation.
Absolutely. Yes. Nita, I think you had
One
something.
other thing, in the executive order that we talked about before, there is also a directive to the Attorney General to look to see where they can bring false claims actions. And David, you'll be talking about that in a minute, but also to look through what we call relators or the whistleblowers and see if there's any around DE&I they can take people down with. And speaking of FCA, David, let's
Yeah.
talk about the first one.
Sure. So the Civil Rights Fraud Initiative, which was launched last spring, and I think some had wondered, is there really something going on? We have reported that various companies had received civil investigative demands or CIDs, which are an indicia that the Justice Department is investigating False Claims Act matters. That's effectively an administrative subpoena. But lo and behold, recently, right around the time of the announcement of the new executive order, we have IBM being announced as having settled a False Claims Act based investigation by the Justice Department. The settlement is 17 million, almost 18 million. And in that, it's very interesting. IBM was accused of violating the non-discrimination obligations under the former 11246. And it basically took the position that by billing the government and certifying through the billing process that they were in compliance with the non-discrimination, that IBM had in fact violated those obligations in violation of the False Claims Act. And they relied on kind of the usual run of EEO claims, compensation, hiring and promotion. They had diversity slates, goals that were used, demographic goals, and restricting programs. This was all what was alleged. I think it's fair to say IBM in the settlement agreement denies that these were violations, but nonetheless, they paid 17 million. Roughly half of that went to contract damages. The government said we had to cancel your contract and we incurred damages. That was about 8.5 million in that settlement, and the rest were penalties. So a final point I would make on this, interestingly, none of the monies collected went to benefit any of the alleged victims. The victims, according to the Justice Department, were whites who were deprived of various employment opportunities, pay or hiring or promotion, because this was not an EEO enforcement. This was a False Claims Act. One of the three barrels on our triple barrel shotgun that we have, we've got the False Claims Act, we have contract cancellation, so part of this was that, and then we have EEO claims that were not part of this settlement. But it is a significant wake-up call, and the clear message we have heard repeatedly around town is IBM is the tip of the iceberg. More of these are coming. More of these are coming.
Well, and so let's take the other part. If we go to the next slide, let's take the other part of the letter, which we really haven't talked about. In order for the government, as we all know, to collect data, they have to put in a paperwork reduction collection with OMB. In the letter to all of the acquisition people, they say that if before OMB approves this emergency 6-month, what's called an ICR data collection, basically, that the agencies can still enforce with existing records that EEOC and DOJ has. So IBM might get a call, from a contracting officer saying, oh, I got this information from DOJ or EEOC based on all the investigations that are going on. Again, whole of government thing that we are seeing. Now, once they get approval, and we'll talk about where that stands in just a minute, they will then be able to come to you and audit like OFCCP did that's what records, books, and accounts is in 11246 when it was originally that was what they would look at to see whether there were violations. You're also reporting your subcontractor violations and lawsuits and so forth. There was a document that was supporting the request for this emergency ICR approval. It was in OMB Monday and Tuesday last week and has vanished. In that document, they had indicated the burden would be less than 2 hours for the contractors and 12 hours for the contracting officers who would be, and there would be somewhere around 6,800 audits conducted this year or over the period of time. And but that has been withdrawn, but I think we can all agree that audits will be coming once either through the existing records, think about Nike, Northwestern Mutual, other EEOC investigations that we don't know about, IBM or other DOJ false claims acts that we don't know about, are ways for them to do this. Other thoughts?
I have a quick one just to put in perspective, because the estimate did assume around 6,800 audits per year. To put that in perspective, OFC, when it was running, OFCCP was conducting approximately 1,000 audits a year. 1,000 audits a year. So we're talking over a six-fold increase in the numbers of audits. Number two, the types of records requested by EEOC and Department of Justice, that is extraordinarily broad. That can encompass multiple years. For example, the Justice Department often goes back 4, if not 6 years, which is the limitation period under the False Claims Act. And the EEOC has also grown increasingly expansive in how it's conducting audits to look for multiple years, patterns, and indicia. So this, we're waiting, as Nita said, for what these requirements will be, but we anticipate that there will in fact be audit activities commenced very promptly, and that they will be very broad.
By separate contracting officers. And
Right.
that's
And we don't quite know how that's going to play out.
We
The
don't.
individual CO is going to be collecting audit information and then lateraling it off. I mean, there's a lot of ways this could go, but we do anticipate audit activity, robust audit activity, is going to occur.
And one thing I wanted to mention, EEOC is not allowed to share what's going on in investigations, but I'm assuming where they go for a subpoena enforcement action like Nike or the Northwestern Mutual, you could probably use that information because that's been put out in the public. But DOJ, I'm not sure how they will be sharing this information. But anyway. All right, now that we've scared everybody half to death, let's go to the next slide. So, David, let's go to what we think everybody should be doing right now. And so let's go to the next slide. And David, we're going to start with you.
Yeah, so I mean, our first action item, gosh, we're already out of date. Immediate was like last Friday. But I think, just to sort of hit on this succinctly, most folks at this point have at least once, and in most cases multiple times, looked at their existing DEI programs. And most of them have tailored them back appropriately in a manner that they believe is compliant with the current executive orders and so forth. So there's the only new call out, I would say, is there's the focus on race and ethnicity. The penalties are now much greater. So you do want to make sure, don't you think, Liz, on that?
I would say, if you were with us during our prior ones where we read yellow, green, and that
Right.
yellow is that risk tolerance area, I do think you need to redefine that risk tolerance under this new lens of
think that's a
the
good way.
new definition of racially discriminatory DEI, because before we were just looking at it under federal anti-discrimination laws as the first executive order framed it. This is a different definition. So I do think you need to relook at your risk tolerance level.
And to the extent that there were reds that people simply said, I'm doubling down on my DEI program, I'm not going to change it. You may want to just revisit that now that the legal risks are potentially much, much greater.
Yeah.
Also, just to call out your procurement arm of your company, you need to make sure that they are fully read in on this, that they are notifying appropriate, that these are not just garden variety, whatever. I mean, as a practical matter, you are going to accept them, but it's important that the organization knows when these new terms have come in, the points we talked about before, that triggers flow down, that triggers your beginning of your potential legal exposures.
Yeah.
So very close coordination there.
Yeah.
One other thing that we've talked about before, and I think we want to reiterate, you're going to need to collect applicant and employee data on hiring, promotions, and layoffs. If you look at the Nike emergency or the Nike enforcement action that they're going at, that's what they're going after is data on every single transaction that has occurred because EEOC believes that they were discriminating against whites and men. So if you don't have and aren't collecting and analyzing the data of your transactions under privilege, how are you going to defend and be able to say to the agency that you, in fact, are compliant with this requirement?
I agree.
Agreed.
The short term obviously is as these contract mods are coming in, new contracts being awarded, these new obligations, and making sure that those are stood up to the extent that you have the points that Liz laid out. That results in further refinement. I think it's prudent to have non-privileged documentation of what you've done so you can show that you not only didn't have scienter or state of mind to violate the False Claims Act, but that you affirmatively took steps to comply. I think that's extremely, extremely important. The
So,
oh, I'm sorry. Go ahead, Nina.
yeah, I think, Liz, did you want to provide some of the short-term requirements as well?
Sure. Building on
Yeah.
building on David's immediate, you need to be able to respond to contractor modification requests on all existing contracts. They're coming in, right? So both new contracts, if you're bidding on something that has not, it should already be in there, but no, if it's not yet, it's coming quickly. And all your existing contracts, reach out to everybody in your procurement officers. Make sure they're aware it's coming in. David was going to make the point of making a list of all of your existing contracts over 15,000 that will require that modification. So be prepared to flow that down. I wouldn't do it proactively, but once your contract gets the contract, be ready to promptly do the flow downs. Develop a monitoring protocol for your subcontractors' compliance. This is going to be, you need to sit down with your internal team and think about what is manageable within your environment, about how you can possibly be managing your subcontracts. What is your volume, and both volume of contracts, volume of staff, and implement something that can actually be facilitated, because you don't want to start a program and then not finish it and have the lack of follow through be the evidence of your failure to take reasonable care in investigating it. And then document all your DE&I program changes and policy updates so that you can evidence the fact that you did assess them under originally assessed them, and now you've reassessed them under this new definition, and that the reasons why you decided to keep them or that you have sunsetted them and the reasons why, so you can evidence those programs. One thing I'd also like to ping on a little bit in reviewing your DE&I programs. This is an ongoing thing, and I'm going to give Sarah the ongoing here in a second. Keep an eye out for, you've assessed it initially, look for managers to be starting programs because they now see a hole in DE&I, and there's some homegrown programs that are popping up locally within divisions and departments, and you need to be getting your arms around those as well.
One other thing, especially as we're not 100% clear what the language around the use of company monies, you need to also assess where are you spending money on groups that might be considered either Blacks or Hispanics or other people that might be considered that might get you into trouble, where it's solely one race or one ethnicity, especially if you don't also do the same thing for white groups, for example.
Assessing your sponsorship programs and the other use of funds. Yes, absolutely.
Well, and
Sarah?
Go for it, Sarah.
Of course, a lot of these, are ongoing, right? But, thinking kind of once we get past this immediate review, what we should be doing, the next is really going to be something like monitoring that ICR that Nita discussed earlier. And that's because it's reasonable to expect that that ICR may provide some insight into what types of data or supporting documents that the government is expecting contractors to maintain or produce. So that's certainly something you want to keep an eye out for. Again, with making sure that there's collection of data, that you are, those are going to be stored somewhere, right? So you want to make sure that that record management system, and you're kind of taking a strategic look really at documentation practices. You might want to reassess, how information is generated and reviewed and retained so that if you need to produce, you've got that efficiently available. We've touched on making sure that you've trained all the different functions, your HR, your procurement, your legal staff, whether you have a DEI office still, whatever that might be. And that needs to be ongoing because there might be turnover. You need to make sure these folks are understanding what the contract clause requirements are, and so that they're kind of working across the board. That's going to be a critical piece. And then lastly, while subcontractor monitoring for their compliance, we've touched on, there's also that reporting of litigation that they bring against the prime contractors or up that supply chain. So you want to make sure that you have protocols there for reporting the litigation as well as compliance concerns.
Well, we have a few minutes left. Let's go through these questions to which we don't have answers. And David, can you talk a little bit about who's going to do these audits?
Yeah, we're not sure, as you've indicated. I mean, it does indicate that the individual contract officers initially are to collect the books and records that it was referred to. So that's step one. But we don't know what's going to happen next. Are they simply going to, for example, use AI and scroll over what information they're provided, looking for hot words or something like that? Maybe. It's unlikely because most contract officers are not trained at all in any EEO matters. Remember, for decades, they have had the Labor Department that monitored that piece of federal contractor compliance. Mm-hmm. So contract officers have just, both in terms of their training and at this point, their DNA, this is not part, they put the clause in. After that, someone else will handle it. So how that's going to work, we don't know. It's possible they could be given some basic training, compile information, identify potential flags, and forward it, for example, to the Justice Department, although they're quite under-resourced. They've had big brain drain for a variety of reasons that we've talked about in other discussions. So there's not a whole lot of people there. They're going to refer to the EOC. That's not fully within their wheelhouse either. The Labor Department, OFC has that big budget, 100 million, not much to do, maybe. Wouldn't that be ironic? OFC repurposed. But the short answer is we don't know, but I think in the next 60 to 90 days, we're going to find out much more.
Yeah. My concern, though, if it is each individual,
a lot of concerns.
Well, yeah. But if it's each individual contracting officer doing this, the scope of the data request is going to be different. What's being asked for? This goes to how far back. I'll just go. The second question leads into how far back will these audits go? I think initially, I think we're going to find a complete lack of consistency in the way the audits are going to be done and how far back they could go. IBM, I believe, was based on went back to 2019 activities. So, and so it's looking back. I would say potentially. I mean, that's a 7-year period, right?
Certainly can go 6 years because the executive order calls out to follow the Justice Department.
Correct.
Minimum. So yeah.
Just so looking back, and that's something to be thinking about, is the land in the world has changed in the last 6 years. So your programs that were in place 5 years ago, 6 years ago are drastically different than they are now. And the IBM matter was based on programs that were in place back then, not necessarily what they were doing today. So, kind of it's going to be an extended run, I think, on some of these audits.
Right.
Well, how are subcontractors? I mean, are subcontractors have to be necessary to contract performance to be covered? What do you think, Sarah?
Right. So I think you've got that still unanswered as well, right? Is this going to be subcontractors that are working under that contract? They have some sort of direct nexus to the work being performed, or is this going to be applicable to every subcontractor, regardless of whether it's relevant to that specific contract? So I think that question remains open.
I mean, I'm going to be devil's advocate here and say if that subcontractor isn't doing work on federal contract, I think that is a step too far under this. I do think
Maybe, but it is written that
we
way,
still-
and there
yes.
are other FAR provisions that are not limited just to those necessary for the performance.
True.
So this
True.
is what, we don't know. And I think most organizations, in terms of practically speaking, they're going to flow it down to everyone.
Yeah.
They're going to peanut butter it across and say, you know what, you're anyone that's on our roster of subcontractor, here it is. Here's a new clause.
Right.
And sort it out from there.
So with OFCCP, David, we did it. It was audits were based on the affirmative action plans, which were set up. Do we have any idea how these audits might be done? I'm assuming it's going to have to be contract specific.
I assume contract specific, which means that the old, again, contrast and compare with what we've learned or experienced with OFCCP. It's no longer a functional AAP limit. It's no longer necessarily a facility. When you look at the contract, anywhere that contract is performed, any folks that are involved in the performance are certainly subject to audit at
Which
a
could
minimum.
be a whole company audit.
Which could be a whole company. Absolutely. Think if you're a defense contractor, for example. A single audit, a single contract could trigger a corporate-wide audit. Now, maybe if you have a particular division that's involved, you could contain it in that manner. But yeah, this is yet another. That's why I'm saying some of these initial potential skirmishes or scoping on what the audit activity is going to be are very worrisome. We may learn more when they ultimately publish what the parameters are of the audits, but at this point, we don't know.
Well, that kind of goes, Liz, to the specific information or data. Again, we don't know, right?
We don't know, but I think we can guess here. First of all, employee data, applicant data, promotion data, termination data, some of that program participation data. Who is getting training? Who is attending conferences? Your funding? What conferences are you sponsoring? Who gets to go to those conferences? I think it could be looking at your supplier, your subcontractor lists, looking at supplier diversity questions, looking at the makeup. What is your spend in supplier diversity?
How many AAs do you have? A Black-owned business, women-owned business?
Correct.
Yep.
Particularly Black-owned business. Argument as to whether women-owned would be within scope of this, since it's focused on race and ethnicity. But
potentially down to your charitable giving. What is your breakdown of charitable giving, and who are you giving it to? I mean, I think conceptually these audits could be incredibly expansive.
Agreed. And at this point, they'll probably give them whatever they want. You get, Sarah, the last word here. We're about to run out of time.
Right. No, I think I'll just touch on real quick. Other open question kind of goes back to who's conducting the audit. Well, who's making the determination that there's disparate treatment, right? Are these contracting officers going to be trained in what constitutes disparate treatment? Or is this going to involve, whether it's a civil rights office, their legal counsel, DOJ or EEOC, whomever, who's really going to be making that determination? That also remains to be seen based off of what we have so far.
Well, guys, we are once again out of time. So thank you so very much. Great to have you with us. And I just wanted to remind you, we do have a great resource page for all of you, and where we have webinars and podcasts. And I think we're just about to get one up, a new podcast, David, with Jonathan Berry. So, all right. And we're off to you, Sarah.
Thanks, Nita. Just like Nita said, that podcast is actually posted today, so everybody can go check that out on the Fortney Scott website. David Fortney did a podcast episode with Solicitor Jonathan Berry. Finally, we'd like to thank you all for joining us today. If you have any further questions, please email us at info@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.